Welcome to the Legal Hour with Bailey and Gallion. We're coming to you today from the Legal Cafe at the corner of Main Street and First in beautiful downtown Fort Worth. Across the street from the courthouse, you can come down and visit with us and have a latte and talk to a lawyer. I'm Keith Spencer, and I'm here today with Jane Mapes. Jane is a family law attorney with Bailey and Gallion in Fort Worth, Texas, and she offices in the Bedford office. And Jane and I have been doing family law for more years than we want to admit, okay? I know we look like young, fresh faces, but it might surprise you that we've been doing this a while. Jane, what brought you into family law?
Well, actually, Keith, I began doing family law when I first joined Bailey and Gallion in 1999, way back in last millennium, as a matter of fact. And I had always wanted to practice family law because I am so interested in helping families make their way through the legal system. And there are so many twists and turns and idiosyncrasies in the legal system that need to be navigated. It really helps to have a dedicated family law attorney to see you through the process.
There was a time before family law was codified, and it was just in the common law. And since then, of course, now we have a family code that spells it all out, and it's bigger than your yellow pages. The funny thing about law is, for any given situation, there's generally a general rule and 453 exceptions to it. And so the difficulty is identifying which, if any, of the exceptions might apply to a certain fact pattern. And you and I have to deal with every day Google and AI and the fact that there are so many well-meaning but uninformed sources of information about any kind of law, and family law in particular. Bubba at the bowling alley, it will give you all kinds of advice, and he means well, but most of the time you don't want to put all your eggs in that basket. Okay? He may be a great guy, but you probably really want to talk to a real lawyer. Is that a constant problem for you as well?
Oh, absolutely. And another issue is that people have these preconceived notions about how a family law case works. Mm-hmm. And they see trials on TV, they see mediations on TV, and I always have to tell my clients before we go to mediation, not to worry, we're not going to all be sitting in a room at a conference table and, jumping across the table and attacking each other. And say, we have a very civilized process for mediations where one side will be with their attorney in one room and the opposing side will be with their attorney in the other conference room. And the mediator practices shuttle diplomacy and goes back and forth between the two conference rooms with offers and counteroffers. And that's how mediation takes place.
So when we're at mediation, like Jane's talking about, we're trying to broker a deal. The mediator is not going to weigh evidence. They're not going to rule on objections. They're just trying to broker a deal. But what's different between real life and television is that we don't practice trial by ambush anymore. So in virtually every case, the parties in both rooms know the facts. They know where the accounts are. They know what documents are likely to come into evidence. So it's not a big surprise. There's rarely a smoking gun. And what I find is that if you'll listen to your attorney, you've got a really good idea about what the court has to do if the judge hears these facts. And the question is, can the two of you come up with a plan that's better suited for your finances and your kiddos than the judge is allowed to give you? I would say more than 90% of my cases settle in mediation because of that.
Absolutely, I agree. And it gives you so much more flexibility and power to mold the final order, either a divorce decree or a modification order, the way that would work best for you and your family, as Keith said. And people need that autonomy when they're talking about their children's lives. The last thing you want to do is have a judge who doesn't know you from Adam making decisions about your children and also about your finances. So mediation is certainly the perfect tool to resolve your family law case. And as Keith said, most cases do settle at mediation. But one thing that people need to know is that it's not a choice usually, because if a case is on a trial track and it's set for trial, one of the things that we must do, that we'll be ordered to do before trial, is to mediate the case to see if we can settle the case without the judge actually having to conduct a contested trial.
When we go to court in the morning for a hearing, the judge frequently has as many as 20 cases on the docket for that morning, and there's no physical way for a judge to handle that many contested hearings. And so a lot of times people get moved over or bumped or things like that, and people wonder, well, why is it so hard to get a hearing? There's a lot of them, okay? And believe it or not, 60+% of the cases in family court are cases between parties where no one has an attorney. They're called pro se litigants, and they don't know what they're doing, and they don't know the procedures, and they can be at a real disadvantage because they can't comply with the rules if they don't know what the rules are. And I'm not beating up on the pro se litigants. Sometimes people have to make difficult choices, but those kinds of cases take longer to hear than when they've been properly organized and the documents have been properly submitted and that sort of thing. And so it's one of those things. Everyone gets a hearing, but it can take a lot longer when you're not sure what you're supposed to be doing.
Right. And certainly the process goes a lot smoother when there are two attorneys in the case. And many times, as Keith said, when we go down to the courthouse, when the judge is calling their docket, what they want to hear is that the cases that are represented by attorneys are out in the hallway negotiating so that the judge actually doesn't have to hear the case, and then the judge can take her or his time with the people who are representing themselves. So the advantage of having an attorney in a contested case is that not only do you have somebody who is obviously well schooled in the law and knows how to present a case to the court, but also an attorney who is knowledgeable and experienced in negotiating and being able to affect a resolution of an issue, part of the case, or the whole case with the opposing counsel. So we really do try to work with our opposing counsel in order to avoid having hearings, which of course also saves our clients time and money and aggravation, because it's certainly not fun being on a witness stand. Nobody relishes the fact that they're going to have to testify, especially in front of a spouse who they're not getting along with, or an ex-spouse who they really don't want to spend very much time with.
A lot of times, you have to remember, there are things that judges are incapable of doing, okay? There are rules that the judge has to follow. It's not that the judge gets to make things up as they're moving along. And fair is something that happens in Dallas in October, okay? So, for example, if someone says, I just don't believe in child support, I just don't think that's right, I want to argue that there should be no child support. Or someone says, I don't care if I'm a drug addict, I'm the mother and the baby needs to be with me, okay? Judges can't just do these things, and so having an attorney, who can help you and tell you, well, that argument's really not gonna carry the day. You really need to think about modifying to something that's more useful and actually gets you some ground. So, for example, they call it the practice of law, I'm told, because it changes every day, and the laws change everywhere. Every time you have a legislative session, and appellate courts are reinterpreting old cases, and that's one of the things attorneys do, is keep up with all of that. This year, we've had some substantial changes and further explanations of rulings that have made this an interesting year for us as attorneys and for anyone who's in family law. One of the things that has changed of late and gotten a great deal more explanation is the fit parent presumption. And Jane, maybe you could tell everybody where that comes from and why we got there.
Okay. Well, there are many times, many situations where somebody other than a parent may have possession of a child. A child may live with a grandparent or a non-relative or another person in their family for whatever reason. Sometimes a parent may have been incarcerated, or a parent may have had a health issue or mental health issue or a physical health issue that necessitated their bringing one of their parents in to take care of their children. And unfortunately, when the parent comes back into the picture and is able to take care of their child again, on many occasions, the grandparent or other relative wants to fight for primary custody of the child and isn't willing to give the child back to the parent. Sometimes they have good reason. They may feel that, the parent is not in the best shape and it's not in the child's best interest to be with the parent. But we have had a lot of case law, not only in Texas, but all over the United States, that has interpreted and codified the rules that apply when a parent is fighting for custody in court against somebody who isn't a parent. And lately in Texas, we finally were able to put the case law that's been in existence for quite a few years now into our family code. And the family code in Texas is kind of like it's our rule book. It is the statutes by which all of our family cases are decided and pled and conducted, along with the rules of civil procedure and the rules of evidence. But now what the family code is saying is that if there is a non-parent who is fighting for custody against a parent, then there is a presumption that the parent always, whether in an original suit or a modification case, that the parent acts within the best interests of the child. And it is in the child's best interest to be with their natural parent versus a non-relative or a non-parent. And what the court now is requiring a non-parent to do is to provide an affidavit along with their first pleading in a case. An affidavit is simply a sworn written statement, and the affidavit must contain facts showing by the use of clear and convincing evidence, which is a higher burden than the normal presumption of the evidence burden of proof that we have in most of our family cases by a preponderance of the evidence. So clear and convincing is a higher standard. It's not quite your criminal standard of beyond a reasonable doubt, but it's also more than just a preponderance of the evidence. And it actually would require the finder of fact, like the judge or the jury, to have a firm belief that those facts in that affidavit are true.
It's important to add to that there were arguments for years that a grandparent might say, well, I have more money, I'm more stable, I'm home all day, I can take better care of the child and afford a better school or even private school better than my kids can, so I think their children should live with me. And while grandparents are frequently a very stabilizing and loving force, sometimes they can overreach a little bit. And so there has been a developing trend in the law to protect parents and their biological children and the relationship between them. It is, and I would argue should be, and most of the courts agree, a very difficult thing for the state of Texas to impede a parent-child relationship. And so the burden of proof is not just, well, I have a bigger house or I make more money or anything like that. You would have to demonstrate that the child is actually in imminent danger to their physical health or emotional well-being if they are placed with their biological parents. And that's a tough burden to prove, okay? Just because you have a nicer car is not going to get it there. And in fact, it goes a step further that Jane was talking about, is you have to have standing. And just the right to have the right to ask the court to place the child with you is a pretty strict level of proof. Otherwise, I mean, I could say, that's a cute kid over there. I'd like custody of that kid. I've never met him before, okay? But you'd have to have standing, meaning a basis for the court to even consider your request. And all of the standing rules change.
Yes.
So I would say that most of the litigation I've seen does involve grandparents.
Yes. It's very rare that you would have an aunt or an uncle or an older sibling.
Or a neighbor.
Right?
Yeah.
Try to obtain custody of a child. But there are many instances where former or present step-parents of children whose parents are separating are trying to obtain custody. And I think that's what the new rule or the changes to the rule have the most applicability. So now, if you are a step parent, number one, even in adoption and termination cases, a step parent does have standing, when the former rule was that the step parent only had standing if they were still married to the parent, and the parent and step parent were petitioners together.
And sometimes this is really difficult. Let's say you have a circumstance where the mother and father live together and are not married, or let's say you've got a stepfather in the house and he's not married to the mother, but he's essentially been raising this child 4 years and is the closest thing to a father this child has. And if mom passes away, it's a real issue as to whether or not the child gets to stay in the home with the stepfather. And those kinds of cases are difficult for the court, but the new rules make it a little easier to prove the standing issue. And that has become clouded for a few years with same-gender marriages.
Yes.
As to whether or not there's a link there that is defensible in court.
Absolutely, absolutely. That was a huge problem. If you had a same-sex marriage and you have one biological parent, then the only way that the other parent, the non-biological parent, would be able to sue for custody and have standing to sue for custody would be to actually adopt that child. Even the fact that they have lived with the child for the requisite number of months and cared for the child and controlled the child, that still wasn't enough for them to get into the courthouse doors. And basically, what standing means is you do have the right to bring this lawsuit in your own stead. So now that the code has changed, it has opened the door to these people that formerly had much more difficult hurdles to jump when they wanted to bring a suit if the relationship between, the parents broke up.
We've had some changes in child support this year as well.
Yes. And the change in child support is that what we call the max for child support, or the maximum amount of the obligor or paying parents' net resources, has increased from $9,200 per month to $11,700 per month, I believe is the correct amount now. And what that does is, number one, obviously these numbers adjust every few years for inflation and dependent upon the economy. But this does, it raises the amount of money that the paying parent has to pay in child support if they are at that level or above that level of income. And we do have many people in Texas who have a lot of self-worth.
Not everyone's going to have to pay the maximum, okay?
Right.
Because it is based on a calculation of a percentage of your income, but the numbers are impressive.
Yes, absolutely. But, there are high net worth people in Texas, and there are high earners, and those people will be subject to that new maximum guideline child support amount.
The court and the state legislature really don't like to see cases where the kiddos have caviar at one house and bologna at the other. Okay, there's a little bit of a field leveling aspect to it to make sure that the children have a stable lifestyle. Okay, it's not really anything other than that.
For sure.
And, we were going to talk about prenuptial agreements and postnuptial agreements. One thing that should be I should be reminding people of is the state of Texas wants these kids taken care of, and they want them fed, clothed, sheltered, and receiving medical care. And to do that, they've adopted a public policy that says you can't reach some kind of contractual agreement that says, I ain't never going to have to pay nothing, no matter what, because the baby needs to eat regardless of whatever your agreement is. And so you cannot contract away the right to receive child support for the benefit of your child.
Absolutely. And that's definitely the public policy of the state of Texas, to protect children's rights when parents are contracting about other issues in their divorce or prior to getting married, when they are contemplating a prenuptial agreement. And many people do come to me for a prenup, and the timing of a prenup is pretty important. I've had clients come into the office, and one of my first questions is, when is the wedding? When are
Tomorrow.
you getting Exactly.
5 o'clock this afternoon.
Right. So either they're going to have to change the date or find another attorney who's willing to walk into a malpractice situation.
You would not believe how many people sign their prenuptial agreements on the altar at the church while they're getting married, and they haven't read them. Okay? And so if you're contemplating marriage and if you're contemplating a prenuptial agreement, give it some time and, make sure that everybody understands what you're doing and that you have given everyone the opportunity to read it and understand it and seek counsel if they need it, and make sure that everyone has a really good feeling for what the assets and liabilities are that are involved in this agreement. One thing that people complain about is how long it takes.
Yes.
To complete a family law case. And that's not just for family law. That happens in all kinds of cases. My goodness, you're entitled to a speedy trial in a criminal case.
Right.
And that's frequently 2 years from now. Okay? What would you tell folks as to what they need to expect in terms of the duration and of a family law matter and why it takes so long?
Okay. Well, first of all, when I'm talking with a potential divorce client, we have a real easy starting point because no divorce in Texas can be finalized until at least 60 days have passed from the date the petition for divorce is filed in the courthouse. So you're going to start off that it's going to take at least 60 days. And then depending upon the issues and how contested the case is going to be, I generally tell my clients that it can be anywhere from 2 months to 18 months. And I say that because although most cases don't go that long, you will have the odd case that will take that amount of time. Generally speaking, most divorces will finalize within a year.
And again, that goes back to mediation as well, because a lot of folks don't want to wait that long. There's not that many issues that they're that far apart about. So why would they want to spend a year or more waiting for trial, spending all the money on discovery and things like that when they don't have to? Many of the courts today are setting, if you filed for divorce today and we went to the courthouse and said, I want to go ahead and set a final trial date so we can light a fire under these Jaspers and get something happening, what kind of response you're likely to get?
That depending upon the kind of trial you're asking for and the length of your trial, how does the summer of 27 sound to you?
And if you want a jury, that's going to take even longer, okay? Remember what we said. There's a whole passel of cases in front of these judges every morning, and they have to fight their way through all of them. And we had a little thing like COVID that slowed some courts down, and judges get the flu and they get iced in at their houses as well.
Sure did.
And stuff happens, okay? And so that's another reason to analyze your case, see how far apart you really are and what you can do to work it out. I find that even folks who are mad at each other can find a quiet time to have a cup of coffee and talk about what's most important to them. How is little Johnny going to continue to play select soccer or whatever is truly important to him? Or how can we craft a visitation schedule that will work with our special needs child?
Sure.
And their needs. Nobody's going to understand that as well as the parents.
Absolutely.
And that poor judge is going to have so little information to go on. That's why we'd like the two smartest people in the room to make the decisions whenever possible.
Correct.
And that ain't the attorneys.
No, that would be mom and dad for sure. Another issue that comes up with respect to custody cases and children's issues is one parent may have a promotion, a job change that is going to require them to move from the area in which they're living right now with the child. And we have in Texas, and I'm thinking in most other parts of the country as well, the courts will impose what we call a geographical restriction on the residence of the child to ensure that the child has a close and continuing relationship with both parents after divorce or separation. And if one party then gets an opportunity to move out of the area to relocate due to their job or another event, then how do we handle the geographical restriction and the relocation issues that are going to come out of that situation?
And a lot of times, the parents can agree on things. These geographical restrictions are barring unilateral moves. By the way, we moved to Omaha last weekend. You'll have to drive up here. No, you can't do that, okay? But a lot of times we find people who say, well, both of our families live in Pennsylvania, and we just moved down here 2 years ago, and she wants to go back to Pennsylvania, and frankly, I might as well, okay? And the parties can reach an agreement, okay? The one good thing about a family law order is that in almost all cases, the parties can reach agreements to go around parts of the order, okay? We have visitation schedules, for example, that say first, third, and fifth weekends, and here's how we do Christmas, here's how we do Thanksgiving. But they all begin with the sentence, access is going to be whatever mom and dad agree on. And if they just can't agree, well, then at least this. And you go into 14, 15 pages typed of rules. And that is so that no one can unilaterally do something silly like, you were white after Labor Day. That's a danger to my child, and I'm not going to let you see him anymore.
Right.
Okay? And so you have to have something that's enforceable. But the courts and the legislature and your attorneys really, really want to see parties agree to the important stuff. We don't want people strapped in. You know, what can we do? Grandma's coming to visit and it's the wrong weekend. You know, can we switch weekends? Of course you can, if you work it out.
Absolutely. And another tool that families use and the courts love, especially these days, are co-parenting apps. Mm-hmm. You know, you may hear about parents who are separated or divorced, each having an app on their phone from one of these co-parenting websites where they can communicate with the other parent only through that app. And they can have calendars through the app. They can do cash payments back and forth, reimbursements of expenses through the app, you know, and scheduling, which is so important when it comes to visitation and school events and things of that nature. So the attorneys generally will agree that, you know, if the parents aren't in a great place communicating with each other, which is, you know, many times that happens in the middle of a controversy, you know, before cooler heads prevail, the attorneys will suggest that both parents get on a parenting app and they communicate that way. And I think that's made a huge difference. And it's, you know, a great tool that co-parents can use now, especially when everyone and the child also has a device in their pocket that can reach anybody in the world at any time.
And I hate it when this happens, and sometimes it does. I would say it's really important for the parents to actually communicate. I see so many people who are very miserable and upset saying, I just can't talk to that person anymore, so I have my girlfriend talk to him, and vice versa. That rarely makes things better, okay? Man up, okay, and talk about what is the most important thing in your life with the other parent and try to get through that. I have a crystal ball at my house because I think every trial lawyer should have one. The doggone thing doesn't work at all, okay? And as talented and experienced as we are as family law attorneys, and our judges are equally talented and experienced and wise people, none of them predict the future very well, okay? And so it is not uncommon for people to divorce or have some kind of family law order that, after some circumstances have changed, doesn't fit very well anymore. How should people handle that, Jane?
That's a great question. And one thing I wanted to relate, a previous judge in Dallas County, Judge Frances Harris, said to me many years ago, she said, Jane, family court orders are written in sand.
There you go.
And what that means, of course, is that they can change. And they should change as circumstances change, as children grow. There are many different examples of changes that will happen, within a child's life. If a parent divorces when a child is 2 years old, you're going to have an absolutely different kind of possession schedule, visitation schedule, than you would when that child is 13, 14, 15 years old. And should the parent be restricted to a visitation schedule for a child under 3 when that child is 16? Well, of course not.
Right.
And so orders can be modified. Many, many times you have a child who has lived with one parent after a divorce or separation for most of their lives. And then they end up in junior high or high school, and they want to see what life is like with the other parent.
That's developmentally appropriate.
Absolutely, especially when it's a same-sex situation. If you've got a little girl who's lived with dad, well, when she's 12 or 13, she might want to live with mom. And then we do have the family code does have rules in place that say, and this is another great misnomer and misunderstanding among lay people, okay? And I will hear it at least once a week. I will hear this from a potential client or an existing client. They'll say, well, I was told that when my child is 12 years old, she can decide if she wants to see her dad or she can decide where she wants to live. Well,
how's that work out?
Not usually that well. What I tell my client is that the law actually says that a child who is 12 years old or older may request to talk to the court about their preference. And the issue is, the rule is that the court must talk to a child at 12 or older if the child requests the court to talk to them. And if the child is younger than 12 and has a request to talk to the court, then the judge, at his or her discretion, may talk to the child. But there is no court in this state that is going to do what a 12-year-old asks them to do only because that's what the 12-year-old is asking.
Judge Lisa Beebe used to say, we don't let kids drive the bus. And so while their desires and wishes are noted and weighed by the court, the 13-year-old boy who comes in and says, I want to move in with Dad because since he got out of prison, he is so much fun to hang with, and we drink beer and he lets me read Playboys. And I don't have to go to school every day. That's probably not going to be a winning argument for the court, who's still looking at what's in the best interest of the child. And you would think that some of these stories that we're telling you are our attempts to be comedians, but they are actual cases that we see every day where people come in, and again, they have strong feelings about it, but there are certain things a court can do and certain things a court cannot.
Absolutely.
So, go ahead, Jane.
Okay, no, I was just going to say, there are certain things that should be left to the parents. But no decision regarding where they're going to live should be left to a 12-year-old. And also, with respect to the child saying, well, I don't want to see the other parent. When you've got that situation, I mean, that's a red flag, and we really have to find out why the child is uncomfortable being with the other parent. Is something going on, or, what is at the bottom of that? And luckily, we do have mental health professionals who devote their time to working with family law cases. We have an arm of the family court system in the courthouse that's called Family Court Services, which employs, 20 or 40 social workers, and they're all master's level social workers and above, to evaluate families when they are in crisis or when there are custody disputes. And, we have other private mental health professionals that will help with these kinds of issues, and will sometimes courts will order what we call reunification counseling for families that have fractured to the point where a child, for whatever reason, doesn't want to see the other parent.
It's really, really important to remember, if you're dealing with a case with children, that children need to be allowed to love and be loved by everyone in their family. And bad-mouthing the other parent or their extended family is harmful to a child, okay? And frankly, there are a lot of adult issues in life that are none of the child's business.
Sure.
Okay? And so you have to not get caught up in the excitement of the trial or the things you see on TV and the gamesmanship, because the person paying the price is usually the child. So, Jane, do you charge anything for people who come visit with you to
No.
talk about a problem?
Not at all.
How can people get in touch with you?
Okay. Well, you can reach me at the Bedford office of Bailey and Gallion, and our phone number is 817-359-7000. And you can schedule a free 30-minute consultation with me, and we have another family lawyer in our office as well by the name of Lori Shannon. And you can speak with either me or Lori, and we can evaluate your case and answer your questions and hopefully help you solve your legal puzzle.
And it costs you nothing to talk to Jane and hear from a real family law attorney rather than your buddy at the bowling alley. And so I would strongly recommend that you take that option because we're dealing with the most important things in your life. I'm Keith Spencer with the Legal Hour from Bailey and Gallion. We hope to see you soon.